Question 1. When implementing new protocols in a shared environment where law enforcement agencies collaborate on investigations across state lines, an issue arises regarding the admissibility of evidence obtained through a multi-jurisdictional sting operation. A suspect was arrested based on wiretap evidence collected in one state but used for prosecution in another. The wiretap was authorized by the original state's court but did not comply with the stricter wiretap laws of the prosecuting state. Under federal and constitutional law, should the evidence be admitted, and what doctrine governs this determination? A. The evidence should be excluded under the fruit of the poisonous tree doctrine because it violated the wiretap laws of the prosecuting state. B. The evidence should be admitted under the good faith exception if law enforcement reasonably relied on the original state's valid court order. C. The evidence should be excluded due to the lack of dual jurisdictional compliance, as wiretaps require compliance with both state and federal law. D. The evidence should be admitted under the doctrine of interjurisdictional reciprocity as long as one state's authorization is valid. Answer. B. The evidence should be admitted under the good faith exception if law enforcement reasonably relied on the original state's valid court order. Explanation. Under the federal wiretap statute, Title Romath of the Omnibus Crime Control and Safe Streets Act of 1968, 18 U.S.C. SSS 2510-2522, evidence obtained via wiretaps must comply with both federal and state laws. However, under United States v. Leon, 1984, the good faith exception to the exclusionary rule allows evidence to be admitted if law enforcement officers reasonably relied on valid court order, even if technical defect later renders it unlawful. A. Incorrect. The fruit of the poisonous tree doctrine applies only when the initial evidence is unlawfully obtained, but here it was lawfully obtained under the original state's laws. C. Incorrect. While some states impose stricter wiretap laws, the key issue is whether federal law permits the evidence. Federal courts tend to prioritize good faith reliance rather than dual compliance. D. Incorrect. There is no legal doctrine of interjuristic reciprocity in wiretap laws, if states maintain independent jurisdiction over such matters. Thus, in the absence of deliberate misconduct, the good faith exception applies, making the evidence admissible. Question 2. During a comprehensive review of a process that needs improvement, a state Supreme Court evaluates whether a judge's failure to inform defendant of the collateral consequences of guilty plea renders the plea involuntary. The defendant, non-citizen, pleaded guilty to drug offense without being informed that deportation was mandatory consequence. The defendant argues that the conviction should be overturned because they were unaware of this under prevailing constitutional law. How should the court rule? A. The plea is valid because collateral consequences are not required to be disclosed under the Due Process Clause. B. The plea is invalid because failure to inform the defendant of mandatory deportation violates the right to effective assistance of counsel. C. The plea is valid unless the defendant explicitly asks about immigration consequences before pleading guilty. D. The plea is invalid only if the prosecutor knowingly withheld information about deportation consequence. Answer. B. The plea is invalid because failure to inform the defendant of mandatory deportation violates the right to effective assistance of counsel. Explanation. In Padilla v. Kentucky 2010, the Supreme Court ruled that defense attorneys must inform non-citizen defendants of deportation risks when pleading guilty. This requirement stems from the Sixth Amendment's guarantee of effective assistance of counsel. If defendant is misinformed or not informed all about mandatory immigration consequence, the guilty plea is considered involuntary. A. Incorrect. While collateral consequences, e.g. loss of public benefits, generally do not require disclosure, deportation is considered particularly severe consequence that must be addressed under Padilla. C. Incorrect. Defendant does not need to ask about immigration consequences for an attorney's duty to arise. The burden is on defense counsel to provide this information. D. Incorrect. Prosecutorial misconduct is not required. Invalidate plea. Ineffective assistance of counsel is sufficient. Therefore, under Padilla v. Kentucky, failure to advise defendant about deportation consequences constitutes deficient legal representation, making the plea involuntary. Question 3. In a high-stakes environment where multiple challenges exist in ensuring fair trials, the court considers whether a defendant's right to confront witnesses under the Sixth Amendment was violated. The prosecution introduced out-of-court testimonial statements from deceased witness through police officers' testimony, claiming the statement was admissible as an exception to the hearsay rule. The defense argues that this violates the Confrontation Clause. Is the correct legal outcome A. The statement is admissible under the dying declaration exception to hearsay, which overrides the confrontation clause. B. The statement is inadmissible because testimonial hearsay requires cross-examination unless the defendant had prior opportunity to do so. C. The statement is admissible because the prosecution's need to present evidence outweighs the defendant's confrontation rights. D. The statement is inadmissible only if the witness's statement was in response to police questioning. Answer: B. The statement is inadmissible because testimonial hearsay requires cross-examination unless the defendant had a prior opportunity to do so. Explanation: under Crawford v. Washington, 2004, testimonial hearsay is inadmissible under the Sixth Amendment's Confrontation Clause unless the declarant is unavailable and the defendant had prior opportunity for cross-examination. Testimonial statements typically include interrogations, affidavits, and formal witness statements. A. Incorrect. The dying declaration exception to hearsay, Federal Rule of Evidence 804b2, allows such statements in some cases, but the Supreme Court has never ruled that this exception overrides the Confrontation Clause. C. Incorrect. The Confrontation Clause is not a balancing test. It is strict constitutional right, meaning necessity does not justify its violation. D. Incorrect. While police questioning often testimonial statements, the key issue is whether the statement was made under circumstances where the declarant would expect it to be used in prosecution. Even spontaneous statements can be testimonial. Thus, without prior opportunity to cross-examine, the statement is inadmissible under Crawford v. Washington, ensuring the defendant's right to confrontation is protected. Question 4. During an emergency response where multiple areas are impacted, law enforcement officials conduct searches without obtaining warrants, citing exigent circumstances. In one case, officers enter a home to search for a suspect they believe to be armed and dangerous based on an anonymous tip. In another case, officers search a vehicle that was abandoned near a crime scene, believing it to contain evidence. The third scenario involves conducting a warrantless entry into a warehouse after noticing suspicious activity inside. Which of the following situations most likely violates the Fourth Amendment's protection against unreasonable searches and seizures? A. The home entry based on an anonymous tip. B. The warrantless search of the abandoned vehicle. C. The warrantless entry into the warehouse based on suspicious activity. D. None of the searches violate the Fourth Amendment. Answer: A. The home entry based on an anonymous tip. Explanation: under the Fourth Amendment, warrantless searches are generally prohibited unless an exception applies. The exigent circumstances exception allows officers to conduct searches without warrants if immediate action is necessary to prevent harm, destruction of evidence, or suspect escape. However, courts require a clear and justifiable reason for the intrusion. Home entry option. Correct answer: Supreme Court has ruled that an anonymous tip alone is not sufficient to justify warrantless home entry. Florida v. J. L. 2000, without corroboration or independent police observation indicating an emergency, such an entry violates the Fourth Amendment. Abandoned vehicle option B. Incorrect. The automobile exception to the Fourth Amendment allows warrantless searches of vehicles if officers have probable cause to believe they contain evidence. Additionally, if the vehicle is truly abandoned, the owner has forfeited their expectation of privacy. California v. 1988, warehouse entry option C. Incorrect. While individuals have some expectation of privacy in commercial properties, plain view and exigent circumstances may justify entry. If officers observed illegal activity from lawful vantage point, entry without warrant may be permissible. Michigan v. Tyler, 1970. This question highlights the limits of exigent circumstances and reinforces the principle that warrantless searches demand higher standard of justification. Question 5. When implementing backup procedures across various investigations, a law enforcement agency develops an internal policy to delay informing suspects of their right to remain silent under Miranda until officers complete an initial round of questioning. They argue that doing so increases the likelihood of obtaining confessions. A defense attorney challenges this practice after a defendant, unaware of their rights, makes an incriminating statement during questioning. Which legal principle is most relevant to determining whether the confession can be admitted as evidence? A. The public safety exception to Miranda warnings. B. The voluntariness test under the Due Process Clause. C. The inevitable discovery doctrine. D. The good faith exception to the exclusionary rule. Answer: B. The voluntariness test under the Due Process Clause. Explanation: Miranda v. Arizona, 1966, established that individuals in custodial interrogation must be informed of their rights, including the right to remain silent and the right to an attorney. Any statement made without a proper warning is generally inadmissible. However, in addition to Miranda, the Due Process Clause of the 5th and 14th Amendments also prohibits the use of involuntary confessions. Voluntariness test, option B. Correct answer. If confession is obtained under coercive circumstances, it is inadmissible even if Miranda warnings were not initially required. Arizona v. Formanante, 1991. Evaluate the totality of the circumstances, including the suspect's mental state, the length of questioning, and whether coercion was involved. Public safety exception, option incorrect. New York v. Qualls, 1984 allows officers to delay Miranda warnings only when immediate danger is present, such as an armed suspect. General policy delaying Miranda does not qualify. Inevitable discovery doctrine, option C. Incorrect. Exception allows evidence to be admitted if it would have been discovered through legal means. Nix v. Williams, 1984. However, it does not apply to confessions obtained unlawfully. Good faith exception, option D. Incorrect. This exception applies to evidence obtained through unlawful searches conducted in reliance on defective warrant. United States v. Leon, 1984, not to intentional Miranda violations. This question underscores the importance of voluntariness in confession law and the strict requirements for Miranda compliance in law enforcement procedures. Question 6. In a case where multiple parties have different objectives, a defendant faces a criminal trial where prosecutors introduce evidence obtained from a co-conspirator's statements made after the alleged crime was committed. The defense argues that admitting this evidence violates the defendant's right to confrontation under the Sixth Amendment. Which of the following statements best describes the legal issue at hand? A. The statements are admissible under the co-conspirator exception to hearsay rules. B. The statements are inadmissible because they were made after the crime was completed. C. The admissibility of the statements depends on whether they were testimonial. D. The confrontation clause does not apply to statements made outside of trial. Answer. C. The admissibility of the statements depends on whether they were testimonial. Explanation. The Sixth Amendment's confrontation clause guarantees defendants the right to confront witnesses against them. In Crawford v. Washington, 2004, the Supreme Court ruled that testimonial statements made outside of court are inadmissible unless the defendant had prior opportunity to cross-examine the witness. Co-conspirator exception, option. While statements made during and in furtherance of conspiracy are admissible. United States v. Burgelli, 1987, statements made after the crime has ended generally do not qualify. Statements made after the crime, option B. Incorrect. While post-crime statements often lack legal protection under hearsay exceptions, they may still be admissible if they are non-testimonial, confrontation clause, and testimonial nature, option C. Correct answer. The key legal test is whether the statements were testimonial or non-testimonial. Davis v. Washington, 2006. If testimonial, they are inadmissible without prior cross-examination. Confrontation clause and statements outside trial, option D. Incorrect. The confrontation clause applies whenever testimonial evidence is introduced in court, regardless of when or where the statements were originally made. This quest teaches candidates how to apply confrontation clause principles to hearsay and co-conspirator statements, an essential topic in criminal trials. Question 7. During a critical transition period where existing processes are being reevaluated, a state legislature enacts a law that allows law enforcement officers to conduct warrantless searches of commercial properties that sell firearms, arguing that such businesses require heightened oversight for public safety. A gun store owner challenges the law, claiming it violates the Fourth Amendment's protections against unreasonable searches and seizures. Would court likely rule A. The law is unconstitutional because it allows searches without probable cause or warrant, violating the Fourth Amendment? B. The law is constitutional because firearm sales are highly regulated and commercial properties have lower expectation of privacy. C. The law is unconstitutional because only federal regulations, not state laws, can impose search conditions on firearms dealers. D. The law is constitutional because the government has a compelling interest in preventing illegal gun sales. Answer A. The law is unconstitutional because it allows searches without probable cause or a warrant, violating the Fourth Amendment. Explanation. The Fourth Amendment generally requires law enforcement to obtain a warrant before conducting a search unless an exception applies, while certain closely regulated industries, such as liquor sales, mining, and firearm dealing, have been subjected to warrantless administrative searches. Courts require that searches be narrowly tailored and part of well-defined regulatory scheme. The Supreme Court in New York v. Berger, 1987, upheld warrantless searches in highly regulated industries, but only when proper limitations exist. Here, law that grants unrestricted search authority without safeguards likely violates the Fourth Amendment. Question 8. In a high-stakes environment where multiple challenges arise simultaneously, a police department facing public scrutiny for alleged racial profiling announces a new community engagement policy that involves stopping individuals in high-crime areas and asking them general questions about their activities even when no reasonable suspicion exists. One individual, who was stopped but not arrested, files a lawsuit alleging that the POP violates the Fourth Amendment. How should the court rule? A. The policy is unconstitutional because it allows stops without reasonable suspicion, violating Terry v. Ohio. B. The policy is constitutional because merely questioning individuals does not constitute a seizure under the Fourth Amendment. C. The policy is unconstitutional because it disproportionately impacts certain racial and ethnic groups. D. The policy is constitutional because high crime areas justify a more flexible interpretation of search and seizure laws. Answer A. The policy is unconstitutional because it allows stops without reasonable suspicion, violating Terry v. Ohio. Explanation. Under Terry v. Ohio, 1968, police may briefly detain and frisk individuals only if they have a reasonable suspicion based on specific and articulable facts that criminal activity is occurring. A policy that allows officers to stop and question individuals without reasonable suspicion are constitutional because it effectively creates a system of arbitrary stops, while officers are allowed to approach individuals and ask questions in consensual encounters. A systematic policy that compels compliance raises Fourth Amendment concerns. Question 9. While analyzing the root causes of sequential problems in eyewitness testimony, a state court implements a new rule requiring all eyewitnesses to be shown a single suspect at a time rather than being presented with a traditional lineup containing multiple individuals. A defendant convicted based on an eyewitness identification under the old system appeals, arguing that the new rule should apply retroactively. What is the most likely outcome? A. The appeal will be denied because changes in evidentiary procedures are not applied retroactively to past convictions. B. The appeal will be granted because new procedural protections must be applied to all pending and past cases. C. The appeal will be granted because the old lineup procedure is now considered unconstitutional. D. The appeal will be denied because eyewitness identification rules are only governed by federal law. Answer A. The appeal will be denied because changes in evidentiary procedures are not applied retroactively to past convictions. Explanation. Under Teague v. Lane, 1989, new procedural rules are generally not applied retroactively to cases that have already been finalized unless the rule significantly impacts fundamental fairness or the accuracy of the conviction. Changes in evidentiary procedures, such as lineup identifications, considered procedural rather than substantive constitutional rules, meaning they typically do not apply retroactively. The old lineup procedure was not unconstitutional, just less reliable than the new system. Question 10. When implementing new protocols in a shared environment, a police department decides to install hidden surveillance cameras in all public parks to monitor for potential criminal activity. The cameras are designed to capture video, but no audio is recorded. A civil rights group files a lawsuit claiming that the surveillance violates the Fourth Amendment. How is a court most likely to rule? A. The surveillance is constitutional because individuals have no reasonable expectation of privacy in public parks. B. The surveillance is unconstitutional because hidden cameras violate the requirement for warrants. C. The surveillance is unconstitutional because recording any video of individuals requires consent. D. The surveillance is constitutional only if the footage is reviewed exclusively for serious crimes. Answer A. The surveillance is constitutional because individuals have no reasonable expectation of privacy in public parks. Explanation. The correct answer is A. Under Catesby, United States, 1967, the Fourth Amendment protects individuals only when they have a reasonable expectation of privacy. Courts have repeatedly held that public spaces, such as parks, streets, and sidewalks, do not provide a reasonable expectation of privacy. This means that law enforcement agencies can record video footage in such areas without a warrant. However, audio recordings might raise it. Wiretapping concerns under the Federal Wiretap Act or state privacy laws. Question 11. During a comprehensive review of a process that needs improvement, a city revises its rules for detaining individuals suspected of gang activity. Under the new policy, officers may detain and question anyone wearing gang-related symbols in designated high-crime areas, regardless of whether the individual is engaged in suspicious activity at the time. A person detained under this policy challenges the rule as unconstitutional. How is a court most likely to rule? A. The policy is unconstitutional because it allows detentions without reasonable suspicion, violating the Fourth Amendment. B. The policy is constitutional because gang-related crime is a serious issue, justifying proactive policing. C. The policy is unconstitutional because it violates the suspect's right to free expression under the First Amendment. D. The policy is constitutional because the presence of gang-related symbols alone provides a justification for police stops. Answer 8. The policy is unconstitutional because it allows detentions without reasonable suspicion, violating the Fourth Amendment. Explanation. Thunder Terry v. Ohio, 1968. Law enforcement must have reasonable suspicion, based on specific, articulable facts, that criminal activity is occurring before detaining an individual. The policy in question targets individuals based solely on their clothing, which does not meet the threat. For reasonable suspicion, courts have consistently ruled that clothing choices alone do not justify stop and frisk actions unless there are additional contextual factors suggesting criminal activity. Question 12. While examining inconsistencies across various units, a new police chief discovers that different precincts use varying definitions of probable cause for arrests. To standardize procedures, department-wide memo states that officers may make an arrest whenever they believe any reasonable person would suspect crime has occurred. Defense attorney challenges the new standard as unconstitutional. What is the strongest legal argument against the policy? A. The policy is unconstitutional because probable cause requires more than just suspicion. It requires reasonable belief that crime has been committed. B. The policy is constitutional because it aligns with general Fourth Amendment principles. C. The policy is unconstitutional because it allows only courts, not police departments, to define probable cause. D. The policy is constitutional because reasonable suspicion and probable cause interchangeable legal standards. Answer A. The policy is unconstitutional because probable cause requires more than just suspicion. It requires reasonable belief that crime has been committed. Explanation. Under Bringer v. United States, 1949, probable cause requires fair probability that crime has occurred based on objective facts rather than a general suspicion. The memo's language, stating that an arrest can occur whenever any reasonable person would suspect crime, creates standard closer to reasonable suspicion, which is lower threshold than probable cause. This reduces the constitutional protections against unlawful arrests under the Fourth Amendment. Question 13. When implementing backup procedures across various jurisdictions, the state police force updates its policies on vehicle checkpoints. Under the new policy, officers set up roadblocks on highways to check for outstanding warrants, stopping every fifth vehicle. A driver who is stopped but not found to have a warrant challenges the stop as unconstitutional. What is the most likely legal outcome? A. The roadblock is unconstitutional because it is not limited to specific safety-related purposes such as due detection. B. The roadblock is constitutional because public safety concerns outweigh individual Fourth Amendment rights. C. The roadblock is unconstitutional because warrant checks are a judicial function, not a law enforcement function. D. The roadblock is constitutional because it applies to all drivers equally and does not impose discrimination. Answer A. The roadblock is unconstitutional because it is not limited to specific safety-related purposes such as due detection. Explanation. The Supreme Court in City of Indianapolis v. Edmond 2000 ruled that police checkpoints must be justified by specific public safety concerns, such as due enforcement or border security. Roadblocks conducted for general crime control purposes, such as checking for warrants, are unconstitutional because they lack an immediate public safety justification. Question 14. During an emergency response where multiple areas are impacted, police officers conduct warrantless door-to-door searches following a natural disaster to look for survivors. While searching a house, officers find an illegal weapons cache and arrest the homeowner. The defendant moves to suppress the evidence, claiming a Fourth Amendment violation. How is the court likely to rule? A. The search is constitutional because it falls under the exigent circumstances exception. B. The search is unconstitutional because natural disasters do not eliminate Fourth Amendment protections. C. The search is constitutional only if officers obtained verbal consent from the homeowner. D. The search is unconstitutional because it was unrelated to the immediate emergency. Answer A. The search is constitutional because it falls under the exigent circumstances exception. Explanation. Under the exigent circumstances exception, law enforcement may conduct warrantless searches when immediate action is required to prevent harm or protect life. Brigham City v. Stewart, 2006. In this case, officers lawfully entered the home to check for survivors, and the discovery of illegal weapons was incidental. Courts typically uphold such searches as long as they were conducted in good faith, not as a pretext for law enforcement objectives. Question 15. In a situation where formal requirements conflict with evolving technology, police use a drone to surveil a suspect's backyard for evidence of drug manufacturing. The drone flies at an altitude of 200 feet. The suspect argues that the surveillance violated his Fourth Amendment rights. How is the court likely to rule? A. The surveillance is unconstitutional because the suspect had reasonable expectation of privacy in his backyard. B. The surveillance is constitutional because airspace is considered public property. C. The surveillance is unconstitutional because police must obtain warrant for all aerial surveillance. D. The surveillance is constitutional because the drone did not physically trespass on the suspect's property. Answer A. The surveillance is unconstitutional because the suspect had a reasonable expectation of privacy in his backyard. Explanation. In Florida v. Riley, 1989, the Supreme Court ruled that aerial surveillance is permissible if it occurs from public navigable airspace and does not intrude on reasonable expectations of privacy. However, in United States v. Jones, 2012, the court emphasized privacy expectations in one's home, surrounding property, curtilage. Drones increase the level of intrusion compared to helicopters, and some courts have ruled that persistent drone surveillance requires warrant. Question 16. During a major transformation where existing methods are being challenged, law enforcement agencies begin using artificial intelligence (AI) software to predict criminal behavior based on an individual's social media activity, location history, and past interactions with police. The software alerts officers to investigate certain individuals flagged as high risk. The Civil Liberties Group challenges this practice as violation. Constitutional protections. What is the most likely constitutional issue at play? A. The use of AI for predictive policing violates the Fourth Amendment because it results in stops and searches without individualized reasonable suspicion. B. The use of AI is constitutional because it does not involve physical searches or seizures. C. The use of AI is unconstitutional because it discriminates against individuals based on their online activity, violating the First Amendment. D. The use of AI is constitutional as long as the police use it solely for data analysis and not for making arrests. Answer A. The use of AI for predictive policing violates the Fourth Amendment because it results in stops and searches without individualized reasonable suspicion. Explanation. Under Terry v. Ohio, 1968, and United States v. Sokolow, 1989, police must have specific, articulable facts supporting a reasonable suspicion that a crime is occurring. AI-based predictions do not constitute reasonable suspicion because they rely on statistical correlations rather than individualized suspicion. Courts have been skeptical of predictive policing methods that result in stops without concrete evidence of wrongdoing. Question 17. While managing a hybrid approach where timing issues complicate enforcement, a state legislature enacts a law allowing police officers to conduct random searches of hotel guest registries without a warrant, arguing that hotels are heavily regulated businesses. A hotel owner challenges the law. How is the court likely to rule? A. The law is unconstitutional because it allows searches without a warrant or probable cause. B. The law is constitutional because hotels are considered public accommodations. C. The law is unconstitutional because it violates equal protection by targeting hotels. D. The law is constitutional because businesses have fewer Fourth Amendment protections than private homes. Answer A. The law is unconstitutional because it allows searches without a warrant or probable cause. Explanation. In City of Los Angeles v. Patel, 2015, the Supreme Court ruled that warrantless inspections of hotel registries violate the Fourth Amendment unless the hotel has the opportunity to challenge the search before a neutral decision maker. The government cannot mandate warrantless searches of private business records unless a exception applies. Question 18. In a high-stakes environment where multiple challenges arise, law enforcement officers enter a home without a warrant, claiming they heard a loud argument and believed someone inside was in danger. However, they find no evidence of violence but do discover illegal narcotics. The homeowner moves to suppress the evidence. How is the court likely to rule? A. The evidence is admissible because the officers acted under the emergency aid exception. B. The evidence is inadmissible because the officers lacked probable cause to enter the home. C. The evidence is admissible only if the officers first obtained consent from the homeowner. D. The evidence is inadmissible because the officers did not witness any crime before entry. Answer A. The evidence is admissible because the officers acted under the emergency aid exception. Explanation. The emergency aid exception allows police to enter home without warrant if they reasonably believe someone inside is in immediate danger. Brigham City v. Stewart, 2006. Since the officers acted on the belief that domestic dispute was occurring, the entry was lawful and any contraband found in plain view is admissible under the doctrine. Question 19. When scaling up operations that experience significant legal challenges, a city police department implements a policy requiring officers to collect and store all traffic stop footage indefinitely. A driver whose footage is retained for 5 years argues that this violates his Fourth Amendment rights. What is the most likely legal issue? A. Retaining footage indefinitely raises Fourth Amendment concerns because it constitutes an unreasonable search and seizure. B. The policy is constitutional because traffic stops occur in public and have no expectation of privacy. C. The policy is unconstitutional because it violates self-incrimination protections under the Fifth Amendment. D. The policy is constitutional because police have a legitimate interest in preserving evidence. Answer A. Retaining footage indefinitely raises Fourth Amendment concerns because it constitutes an unreasonable search and seizure. Explanation. In Carpenter v. United States 2018, the Supreme Court ruled that prolonged surveillance raises Fourth Amendment concerns. While traffic stops are public, indefinite storage of personal interactions with law enforcement could be seen as an unreasonable retention of personal data under the Fourth Amendment privacy protections. Question 20. During the introduction of new methods where coordination between agencies is critical, federal authorities implement a policy requiring all local law enforcement agencies to share real-time location tracking data from mobile devices. A civil liberties organization challenges the policy. What is the most likely constitutional argument against it? A. The policy violates the Fourth Amendment because real-time location tracking requires a warrant. B. The policy is constitutional because law enforcement agencies routinely share intelligence. C. The policy is unconstitutional because it violates the 10th Amendment's restrictions on federal overreach. D. The policy is constitutional because individuals voluntarily share their location with phone companies. Answer A. The policy violates the Fourth Amendment because real-time location tracking requires a warrant. Explanation. In Carpenter v. United States 2018, the Supreme Court ruled that real-time and historical location tracking requires a warrant because it constitutes a search under the Fourth Amendment. A blanket policy mandating real-time tracking without individualized suspicion would likely be unconstitutional. Question 21. In a multi-location scenario where consistency requirements differ, two neighboring states adopt conflicting vehicle search laws. One allows warrantless vehicle searches based on probable cause, while the other requires a warrant for all vehicle searches unless exigent circumstances apply. A driver is pulled over while crossing state lines and officers from both states are involved. The driver challenges the search. What is the most likely legal outcome? A. The search is unconstitutional if it occurred in the state requiring a warrant regardless of the other state's laws. B. The search is constitutional because vehicle searches have fewer protections than home searches. C. The search is unconstitutional because officers from two different jurisdictions participated. D. The search is constitutional because officers acted in good faith. Answer A. The search is unconstitutional if it occurred in the state requiring a warrant regardless of the other state's laws. Explanation. The correct answer is A. The Fourth Amendment applies based on the state where the search occurred, not the officer's jurisdiction. If state requires warrant for vehicle searches, officers cannot bypass this requirement by relying on another state's laws. Question 22. During an emergency response where multiple areas are impacted, police set up a roadblock to search vehicles for disaster relief supplies being looted. A driver refuses to stop and is arrested. The driver challenges the arrest. What is the strongest argument against the roadblock? A. The roadblock is unconstitutional unless it serves an immediate public safety purpose. B. The roadblock is constitutional because disaster zones allow emergency enforcement. C. The roadblock is unconstitutional because it violates the driver's right to travel. D. The roadblock is constitutional because it applies to all drivers equally. Answer A. The roadblock is unconstitutional unless it serves an immediate public safety purpose. Explanation. Under Indianapolis v. Edmond, 2000, roadblocks are only constitutional if they serve specific public safety-related purposes. A roadblock targeting general crime control, such as stopping looters, does not meet this requirement. Question 23. During a seamless transition where continuity must be maintained, a state law is passed requiring all criminal suspects to provide their social media passwords to law enforcement upon arrest. A defendant challenges the law as unconstitutional. What is the most likely legal issue? A. The law violates the Fifth Amendment privilege against self-incrimination. B. The law is constitutional because social media accounts are public records. C. The law is unconstitutional because it violates the Fourth Amendment's protection against unreasonable searches. D. The law is constitutional as long as the police have probable cause. Answer A. The law violates the Fifth Amendment privilege against self-incrimination. Explanation. In United States v. Hubbell, 2000, the Supreme Court ruled that compelling a suspect to disclose information that could be used against them violates the Fifth Amendment. Requiring someone to provide passwords is akin to forcing them to reveal the contents of their mind, which is considered self-incrimination. Question 24. In a situation where formal requirements conflict with modern law enforcement needs, a police officer is investigating an online fraud case. The officer obtains a warrant to search a suspect's smartphone but delays execution for 6 months due to backlog. By the time the phone is searched, the suspect argues that the warrant is no longer valid. What is the most likely ruling? A. The search is unconstitutional if the delay caused the warrant to become stale. B. The search is constitutional because a valid warrant was issued. C. The search is unconstitutional because digital evidence is subject to stricter time limits. D. The search is constitutional as long as the evidence on the phone is still relevant. Answer A. The search is unconstitutional if the delay caused the warrant to become stale. Explanation. Under the staleness doctrine, a warrant must be executed within a reasonable time to ensure that the evidence sought is still relevant. Courts have ruled that delays of several months can invalidate a warrant, particularly in cases involving rapidly changing digital evidence. Question 25. While updating traditional approaches where interconnections between different rights are becoming more complex, police conduct a drone surveillance operation over a suspect's backyard for several weeks without warrant. The suspect argues that this violates his constitutional rights. What is the most relevant legal precedent? A. The surveillance is unconstitutional under Carpenter v. United States, 2018, because prolonged monitoring requires warrant. B. The surveillance is constitutional because aerial surveillance is permitted under California v. Suriello, 1986. C. The surveillance is unconstitutional because drones cannot be used for law enforcement purposes. D. The surveillance is constitutional because the suspect's backyard is visible from aspects. Answer A. The surveillance is unconstitutional under Carpenter v. United States, 2018, because prolonged monitoring requires a warrant. Explanation. In Carpenter v. United States, 2018, the Supreme Court ruled that long-term electronic surveillance requires a warrant, while California v. Suriello, 1986, allowed brief aerial surveillance. Prolonged drone surveillance raises serious Fourth Amendment concerns. Question 26. During a major transformation where existing methods of collecting evidence are challenged, a police department installs hidden microphones in public parks to detect conversations about criminal activity. The suspect's conversation is recorded, leading to his arrest. The suspect argues this is unconstitutional. What is the most likely legal issue? A. The use of hidden microphones constitutes an illegal search under the Fourth Amendment. B. The suspect has no expectation of privacy in public place, making the recording lawful. C. The recording is unconstitutional because it violates Miranda rights. D. The recording is constitutional because police regularly use informants to gather verbal evidence. Answer A. The use of hidden microphones constitutes an illegal search under the Fourth Amendment. Explanation. In Katz v. United States, 1967, the Supreme Court ruled that even in public places, individuals have an expectation of privacy in their conversations if they take steps to keep them private, using hidden microphones to record conversations without a warrant is likely an unconstitutional search. Question 27. In an environment where different components of law enforcement must interact, a police officer pulls over a driver for speeding and, without probable cause, orders the driver to turn over their phone for inspection. The officer finds evidence of drug trafficking. The driver challenges the search. What is the most likely outcome? A. The search is unconstitutional because it violates Riley v. California, 2014. B. The search is constitutional because the phone was unlocked. C. The search is unconstitutional unless the officer found probable cause after the stop. D. The search is constitutional because traffic stops are routine law enforcement procedures. Answer A. The search is unconstitutional because it violates Riley v. California, 2014. Explanation. In Riley v. California, 2014, the Supreme Court ruled that police must obtain a warrant to search a phone even during an arrest. A routine traffic stop does not justify warrantless phone searches under the Fourth Amendment. Question 28. When improving a process that shows unexpected results, a state police department starts using facial recognition software to scan public crowds for wanted individuals. A man is mistakenly identified as a fugitive and arrested. He later proves that the software was incorrect. What is the strongest legal argument against the use of this technology? A. Facial recognition software leads to unconstitutional arrests based on unreliable probable cause. B. The use of facial recognition software is constitutional because it is a tool for public safety. C. The arrest was lawful because police had reasonable suspicion to detain the individual. D. The use of facial recognition software is unconstitutional because it violates due process. Answer A. Facial recognition software leads to unconstitutional arrests based on unreliable probable cause. Explanation. Courts have questioned the reliability of facial recognition technology as a sole basis for probable cause. If a mistaken match leads to an arrest, it raises Fourth Amendment concerns because the police lacked individualized suspicion. Question 29. During a comprehensive review of a process that needs improvement, an officer arrests a suspect based on an anonymous tip that he possesses an illegal firearm. The officer conducts a pat-down and finds the weapon. The suspect moves to suppress the evidence. What is the most likely ruling? A. The evidence is inadmissible unless the tip was corroborated by independent police observations. B. The evidence is admissible because the officer had reasonable suspicion based on the tip. C. The evidence is inadmissible because firearm possession is not a justification for a stop. D. The evidence is admissible as long as the firearm was visible during the pat-down. Explanation. Answer A. The evidence is inadmissible unless the tip was corroborated by independent police observations. In Florida v. JL 2000, the Supreme Court ruled that an anonymous tip alone is insufficient for a stop and frisk unless it is corroborated by police observations. Question 30. In a case where multiple parties have different objectives, an undercover officer records a conversation with a suspect without obtaining a warrant. The recording is later used as evidence in court. The suspect argues that this violates his rights. What is the most likely ruling? A. The recording is admissible because one party consented to the conversation. B. The recording is inadmissible because it was obtained without a warrant. C. The recording is unconstitutional under the Fourth Amendment. D. The recording is inadmissible because undercover officers cannot use secret recording devices. Answer A. The recording is admissible because one party consented to the conversation. Explanation. Under United States v. White 1971, an individual does not have a reasonable expectation of privacy in a conversation if they are speaking to someone who consents to recording, even if the other party is an undercover officer.